Sure. I'm Randy Barnett. I'm the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center, where I also direct the Georgetown Center for the Constitution. Well, I've only done it once. I don't really aspire to do it again. I'm glad I did it once. I was also in a science fiction movie once. I don't necessarily have to be in that again either. And it was an amazing experience. I have to say I was more anxious, if not fearful, for a longer period of time than I have been in my entire life. For like a 6-week period of time, I just had this pit in my stomach that I was going to be doing this. The day of the argument, I didn't feel that way, which was really remarkable to me. After having lived with this adrenaline for 6 weeks, I felt, like I used to feel when I was trying a jury trial. Not normal, I would say, but sort of wired and ready to go. And I think that I was, after I kind of, my voice caught on the second sentence that I said, which I sort of identified with Attorney General Varelli's difficulties that day. I had a similar problem. But then I think once they started hitting me with questions, I was able to respond, which is why they hit me harder. I think if you can't respond, they go easy on you. If you can respond, they keep hitting you harder. And it turns out that for accidental reasons, the only justices who asked me questions that day were the ones that voted against our position. And anyone who's argued in front of the court knows that you really are looking for those little life preservers you get thrown by the justices who are on your side. Well, counsel, couldn't you really say this? But the 3 votes that we got in the Raich case was Chief Justice Rehnquist, who was seriously ill and was not in court that day, Justice O'Connor, who asked some really tough questions of Paul Clement, who is the acting Solicitor General at the time, and Justice Thomas, who doesn't ask questions. And so I got no help from the justices who ultimately voted for our side, and I took it pretty hard from the justices who were on the other side. But I've listened to that oral argument. I sign it. I sometimes play it for my students, and I have to say they were very gracious to me. They were very polite to me. They were tough, but they were always respectful. And I have no complaints about how I was treated by the court at all. I'm just glad I was able to stand up to what was really a pretty tough day to be an advocate in front of them. Yeah, during the argument, it was quite apparent to me, you stand very close to the justices, and so you really have a sense of their body language and their facial expressions, even in a way that if you're sitting in the bar section, you don't quite see as much, and certainly not if you sit in the gallery. And I really could tell that Justice Kennedy was not with us. He was really, unusually for him actually, somewhat visibly hostile to our side. I don't know why exactly that was true, but I sensed it at the time. And Justice Scalia, whose vote we needed and who we lost, he actually was not as tough. His questions were the hardest questions I got and the ones I had the most difficult time answering, but he wasn't viscerally as antagonistic or hostile to our side as he sometimes can be. He wasn't dismissive in any way. So we could hope that we might have retained his vote. And maybe at that time he hadn't fully made up his mind, but Justice Kennedy didn't look good, and so I walked out of there not very optimistic. The opinion doesn't come down for months later, so by that time I could talk myself into the possibility that, oh, wait a second, maybe we got everybody after all. But on the day, while it was happening, it didn't look like it was happening. Yeah, it's true. I do think I felt that my answers kept getting interrupted, and if you don't get your answer out in one sentence, you're not going to get 2 sentences with a hot bench, with a bench that's really arguing with each other about things. And so it was frustrating. I did feel that frustration. I've listened to the oral argument. As I say, I didn't listen to it for quite a while because it was kind of painful, frankly, to try to think about listening to it. But then because I was teaching, I played it for my students. It's not as painful anymore. It's a little bit painful, but that's probably because I know the outcome. If we won the case, I'd be fine with it. But the truth is, I think I got my argument out. I do think it got out. So I think I made the argument, and so one way or the other, even though I was being interrupted, I was able to get it out anyway. And I think that's your job as an advocate, is even when you're being interrupted, you've got to get it out. I think I did get it out. They disagreed with the argument. It's not because they didn't hear the argument, it's because they didn't agree with it. Well, sort of the secret here is that 3 weeks before oral argument, when I was doing a moot court at the Georgetown Law Center, before I was on the faculty there, we discovered a big hole in our argument that would have been a disaster if we hadn't somewhat modified our position. Basically, to simplify it without going into the details of what it was legally, there's always concern about the slippery slope questions, and I always knew that this was an issue going, in the case. I'd been writing the briefs for 2 years, and I thought I had an answer to the slippery slope question, and then during this moot court, the first moot court, it turns out my answer did not work, and I could not get off the slippery slope, which would have been a disaster. And so ultimately, I had to modify our argument from the brief, even though if I had been asked about that, I would have been able to explain why I wasn't really modifying it from the brief. But I went through 2 more moot courts in which I practiced. In the next moot court, they didn't ask me the right questions, so I didn't get to practice it. My final moot court, 6 days before argument, was at the Harvard Law School. They did ask me the right series of questions. I tried out my new answer, did not execute it that well, but it still got me off the slippery slope. So on the day of the argument, I was prepared to be a lot clearer, and the reason why I needed to be clearer is because it wasn't quite what we were arguing in our brief, and therefore it was likely to confuse the justices because they're going to expect me to say one thing and I'm saying something else. So I was really clear, and I had a wonderful exchange with Justice Ginsburg on this issue, and she asked me a beautiful setup question and even a more fantastic follow-up question. I will always be indebted to her for this. And I got the view out, and I think it changed the whole dynamics of the argument, because at that point we're now all arguing about something that isn't quite in the brief. We were all on the same boat in that respect. And Justice Breyer took strong issue with what I was saying. However, we were off the slippery slope, and therefore I'd survived. If it hadn't been for that alteration in our view and on our position, I would have been destroyed in the first 5 or 10 minutes, and then it would have been pitiful. This is, who listens to SCOTUSblog if not Supreme Court lawyers? So I'll give you my opinion about that. They're extremely smart. They're extremely good. Most of the time you want to hire one of those guys as opposed to somebody who hasn't been there before. And the most important reason is that they know the justices, they can interpret what the justices' questions, where they're coming from. What you really want to do is you want to answer the justice. You don't want to debate with a justice. You want to answer the justice if you can. You want to satisfy the justice, or at least you want to give the other justices the right argument to use against that justice. So you really need to know what you're doing, and the Supreme Court bar does, and that's the reason why they're good. However, there is a problem sometimes, and that is they are repeat players, meaning they have a very strong stake in their own reputation in front of the court, and that makes them mainstream in the sense that they may not want to argue or make what they consider to be a deviant argument, or an argument that would undermine their long-term credibility with the justices who they must maintain this relationship with, in which they're kind of selling their rapport to their clients. That means when a case comes in that requires a different kind of argument than they feel is respectable, they're not likely to want to make it. They're going to want to trail off and maybe not do that. And I think the case I was involved with in the Raich case, making the Commerce Clause argument that we were arguing, there are many Supreme Court advocates who just would not feel super comfortable making it. And truthfully, if they made that argument, everyone in the room would know they didn't really believe it. At some point, it's useful, it's helpful for an advocate to get up in front of the court who actually believes the words that are coming out of their mouth and has thought about it. And I had the benefit of having a reputation as an academic who had worked in the Commerce Clause area and knew that stuff. And so it put me in a somewhat different position than your average practitioner who's never been in front of the court before, because first of all, I've studied the justices, so I know where they're coming from, and so I'm not oblivious to that. But secondarily, it was quite clear that I believed what I was saying, and I understood the position I was taking, and it was because of that understanding of that position that I was able to modify our argument and save us from disaster, when I think many advocates, I won't say all, but I would say many advocates would just feel uncomfortable moving away from their brief 3 weeks before oral argument in front of the Supreme Court. God, you know, it's so funny. I was about to say that. It's amazing that you intuited that was the next thing on my mind, which is that when you're a prosecutor, you make seat-of-your-pants judgments up in front of everybody. The jury's watching you, the judge is watching you, and you're doing things, on the spot, and you're changing your position, and you're responding to things on the spot. And I think it was that experience that gave me as a lawyer, that gave me the confidence to say, we're in trouble. This argument does not work. We must make a change. It doesn't matter, and hopefully to a better position, but we can't we can't stick with what we've got. We've got to do something else. And I was able to do that, I think, in part. I was able to make that move in part because of my prosecution background, I have to say.